Hi, my name is Jordan Walker. I'll be your narrator today. I am an attorney at Seaver Story Law Firm, an eminent domain only, landowner only law firm based out of Indiana. Today we're going to be talking about the Dakota Access Pipeline Project. This is a seminar intended for landowners to get some more education, some more information on the project. Again, my name is Jordan Walker. I'm with Seaver Story Law Firm. This is being presented on behalf of Seaver Story and in conjunction with Seabrecht Law Firm in Iowa and the Professional Institute for Landowner Attorneys and Appraisers. Real quick, just to discuss who Seaver Story is, or what they are rather. Seaver Story, we are a eminent domain landowner only law firm. We only do eminent domain. We do not do anything else. We are located, our headquarters is located in Indianapolis. However, we have offices in Illinois, Kentucky, Ohio, and North Carolina, and we also have local council agreements in Iowa, Missouri, and several other states where our services are needed. Our mission today as a law firm, and really as people who have experienced this quite a bit and worked with several hundreds of landowners faced with eminent domain, is to educate everybody on really the project and the legal background and what to expect moving forward. There's a lot of information and misinformation out there, and we're here to clear it up a little bit, and at the very least, make sure all of the decisions for landowners that are affected by this pipeline are at least based in experience and education. Let's talk about the project real quick. It's a very large pipeline, to put it simply. 346 miles of the pipeline will be in Iowa. Another 180 or so will be in Illinois. It starts in North Dakota, works its way all the way down to south central Illinois. It is a crude oil pipeline, a 30-inch pipeline, I should say, as well, which, as far as pipelines go, are pretty big. It's a pretty sizable pipeline. Normally, they're between 20 and 25 inches. This is obviously 30. Here's a rendering of where the pipeline is going specifically. As you can see, it starts in the northwest part of North Dakota, works its way down southeast through South Dakota, Iowa, and then eventually ending, as I said, in Illinois, south central Illinois. Let's talk about what's going on right now with the project. Right now, the Dakota Access Pipeline, they are seeking permission from the Iowa Utilities Board to build a pipeline and also to take property via eminent domain if necessary. We'll talk about what eminent domain is here next, but let's just talk about what's going on right now. There is a decision that's expected on both of these issues by the end of December 2015 from the Iowa Utilities Board. The reason they need this permission is that as a private pipeline utility, the Dakota Access Company does not have eminent domain authority. So unlike, say, the Iowa Department of Transportation or local municipalities who inherently have eminent domain, this pipeline company must seek permission from the Iowa Utilities Board to have that authority. Now, while nothing is final as of right now, this being late October, we're going to assume for the rest of the presentation that they will get eminent domain and operate under that hypothesis. What is eminent domain? I've already said it a couple times. Eminent domain is, pretty simply put, the right to take land for a public project. The most common and traditional idea or purpose of eminent domain is for roads. And that really has what has dominated the use of eminent domain throughout much of its history in America has been roadways, interstates, highways, and the like. However, the new eminent domain, or at least what we're seeing here in the last 5 years and what we anticipate to be the case moving forward, is eminent domain used for power line projects, for pipeline projects, for energy-related transmission projects, to move energy from one place to another, this being one of those projects. The back-end fields up in North Dakota are a prime source for energy, and they need to get somewhere. So as a result, there are several pipelines that are being built, starting in that location and moving to large oil and energy distribution centers around the country. the one in south central Illinois being a prime one. So essentially, back to eminent domain, what it is the right to take land, regardless of what the landowner wants. Now, it should be noted that just because they can take it doesn't mean they can name the price. That is a common misconception. There is a fight to be had. While traditionally the fight is not over whether they can take it, the fight is over how much money the landowner is entitled to. And that's predominantly what we'll talk about today. Every single landowner on this project, in particular, will deal with three different issues. They will deal with what the easement says, they will deal with the fair market value of their land, and in our opinion, most importantly, they will deal with the residue damage impact of the pipeline on the land or farm's value. Let's talk about each thing. An easement is essentially what they're asking you to sign. Oftentimes it's referred to as the contract or the document that governs the rights of the pipeline. The biggest question we get is, what can the pipeline do? What are they allowed to do? Are they allowed to do this? Are they allowed to do that? What are their rights? And my answer to that every single time is go to the easement. What does the easement say? This will say exactly what they are allowed to do. If it doesn't say they can do it, it's pretty simple. They can't do it. Now, on the flip side, if it says they can do it, then therefore, on the other side, the landowner cannot interfere or impact those rights that are explicitly granted. It's incredibly important to review this document and make sure it is crafted and tailored as to be, at the very least, landowner friendly, or not as cumbersome as what the pipeline would like it to be. Oftentimes, right-of-way agents in the pipeline will vocalize what they think is in the easement, and then what ends up happening is that the wording in the easement is actually different from what's said. This happens a lot. So it's very important to review that document, have an attorney review it as well, and make sure the rights of the pipeline are limited to only what they need. Oftentimes, utility companies will try to sneak in rights in there that allow them to sell or sublease rights within the easement to other companies. It's important you don't let them do that. Second issue, and I won't touch on this too much because, and we'll talk about why in a bit, but the basics of it is that it is part of the equation, but it's not the most important part of the equation. And that is the fair market value of the taking. So in other words, if they need 4 acres from you, what is the price per acre of that 4 acres? What is land going for in that area? Oftentimes, utility companies and pipelines in particular will offer good or higher than what is fair market value for price per acre. So in other words, if land's going for $13,000 an acre, they'll offer 15. The reason why they do that is because they don't want you talking about the third thing. So when you see an offer that has a high price per acre, be wary. Be wary because there's a reason they're giving that to you, and that's so you avoid the third topic, and that is residue damage. And this is the most important part of your case, if you ask me. Residue damage is the impact the pipeline has on the value of the remainder of the property. Sometimes it's referred to severance damage, sometimes it's referred to remainder damage. It's all the same thing. What is the impact that the pipeline has on the value of the rest of the property? This number can multiply very quickly, and that's the reason why the pipeline doesn't want you talking about it, because there's a big difference from going from $13,000 to $15,000 for the acquisition than there is going from 5% to 20% impact on the rest of the property because of the pipeline. Let's show a hypothetical situation. So here's 2 different parcels. You have parcel A and parcel B. They're right next door to each other. They are virtually identical. The crop yields are the same, everything, their shape's the same, everything's identical except for one key difference. Parcel B has a pipeline, covers 4 acres of the property. So because of that pipeline, depending on you ask, this can run between 5, 15, 20, 25, 30% impact on the rest of the parcel. That is the remainder damage, so to speak. So while parcel A is unencumbered and without a pipeline, it goes for the standard $13,000 an acre. Parcel B no longer goes for $13,000 an acre. It has lost a significant amount of value, $200,000 almost, and as a result, it is less valuable because of that pipeline. look at it this way. If you're a buyer of farmland and you walk up to both of these parcels, are you going to pay the same amount for either one? No, of course not. You're going to pay less for parcel B. Why bother with that parcel that has the pipeline on it when you can get the same thing for fair market value? So when parcel B had that pipeline put on it, it would be important that they get compensated for this impact on the rest of the property. So if you take the 4-acre easement at $13,000 an acre, that's worth $52,000. Pretty simple math. They bought the 4 acres, they got to pay $52,000 for it. But what's more important, as you can see, is that according to an appraisal expert, this pipeline would have a 15% damage on the rest of the parcel if the parcel were to be sold. And as a result, at the time of the acquisition, the landowner would be entitled to another $200,000, that impact on value. You add those two numbers together and you get what the landowner was entitled to when they sold the easement to the pipeline company. Put yourself in this landowner's shoes. You are the 100-acre parcel B owner, and the pipeline offered you $52,000 for your easement. Had you taken that, or even had you bumped it up to $15,000 an acre, which would result in a $60,000 total compensation package for the easement, you still would have been leaving close to $200,000 on the table by taking that offer. That's why it's incredibly, incredibly important to address this residue damage issue when the Dakota Access people approach you. So what is going to happen next? Well, Dakota Access is preparing for eminent domain. They are in the throes of discussing eminent domain with the the Iowa Utilities Board. So that it's expected, if it gets approval, that eminent domain will also get approved, which means you're talking about eminent domain lawsuits filed against landowners happening probably in early 2016 if all goes to plan, according to Dakota Access plan. So what does that mean? It means now is the time to start thinking about legal representation, or at the very least what you're going to do. What is your plan? If you don't have a plan, now is the time to get one. If you have an offer and you think it's great, if you have an offer and you have no idea what to make of it, luckily our firm offers free case reviews. So it's as simple as shoot me an email at the email address you see there, or giving me a call at that phone number, and we can talk about your case for absolutely nothing. I don't charge. We don't operate like that. We have no problem giving our advice or our at least thoughts on on your case as it stands. So it doesn't hurt. Just give us a call. We'd be more than happy to talk about your case. If you have any questions about this presentation, about our firm, the Dakota Access, eminent domain, or really anything else, again, feel free to give me a call at that number. My name is Jordan Walker, 1-888-318-3761, or give me an email at Jordan, Jordan, @landownerattorneys.com. Thanks.